obtaining information from NSA surveillance. Reuters reports that the IRS got intelligence tips from DEA's secret SOD unit and were also told to cover up the source of that information by coming up with their own independent leads to recreate the information contained from SOD. So let me explain what happens. We once again use a lower standard, a non-constitutional standard, a thing we're supposed to be using for terrorists. We get information on people who are not terrorists, who may or may not be committing an IRS violation. We tell the IRS they know it's illegal obtained information, so then they look for another way to prove that this information, other information that they can find to prove the point they only knew about from illegally obtained information. A startling new Reuters story shows one of the biggest dangers of the surveillance state: the unquenchable thirst for access to the NSA's trove of information by other law enforcement agencies. As the NSA scoops up phone records and other forms of electronic evidence while investigating national security and terrorism leads, they turn over tips to a division of the Drug Enforcement Agency known as the Special Operations Division. FISA surveillance was originally supposed to be used only in specific authorized national security investigations. But information sharing rules implemented after 9/11 allows the NSA to hand over information to traditional domestic law enforcement agencies without any connection to terrorism or national security investigations. Instead of being truthful with criminal defendants, judges, and even prosecutors about where the information came from, DEA agents are reportedly obscuring the source of these tips. For example, a law enforcement agent could get a tip from foreign surveillance, and he could look for a specific car at a certain place. But instead of relying solely on the tip, the agent would be instructed to find his or own reason to stop and search the car. Agents are directed to use these sweeps under wraps and not to mention their reports or where they got the information. If we're going to use standards that are less than the Constitution for IRS investigations, for drug investigations, we ought to just be honest with people that we're no longer using the Constitution. If we're going to use the Constitution, then we shouldn't allow evidence obtained through foreign surveillance and through a lower standard to be used in domestic crime. Parallel construction, which is basically getting surveillance tips and then using them, reconstructing, and trying to come up with a different reason for why you stop someone, is something that really, if we're not going to be honest about it, someone has to do something to fix this. After an arrest was made, agents then pretend that their investigation began with a traffic stop, not with the tip they got from our foreign surveillance agencies. The training document reviewed by Reuters refers to this process as parallel construction. Two senior DEA agents who spoke on behalf of the agency, but only on condition of anonymity, said the process is kept secret to protect sources and investigative methods, but realized they're also keeping it secret from the judge, the defense lawyer, and the prosecution. Some have questioned the constitutionality, obviously, of this program. That's outrageous, said Tampa attorney James Fellman, a vice chairman of the criminal justice section of the American Bar Association. It strikes me as indefensible. Lawrence Lustberg, a New York defense attorney, said, any systematic government effort to conceal the circumstances under which cases begin would not only be alarming, but pretty blatantly unconstitutional. Former federal prosecutor Henry Hockmeyer wrote, "You shouldn't be allowed to game the system. You shouldn't be allowed to create this subterfuge. These are drug crimes, not national security cases. If you don't draw the line here, where do you draw it?" This is an article from the Washington Post by Brian Fung entitled, "The NSA is giving your phone records to the DEA, and the DEA is covering it up." A day after we learned of a draining turf battle between the NSA and other law enforcement agencies over bulk surveillance data, it now appears that these same agencies are working together to cover up when this data gets shared. The DEA has been the recipient of multiple tips from the NSA. Realize also the NSA is supposed to be investigating foreign threats, okay? The NSA was not supposed to be doing anything domestically. We now have them involved in bulk collection, but we also have them now involved in drug enforcement. DEA officials in a highly secret office called the Special Operations Divisions are assigned to handle these incoming tips, according to Reuters. Tips from the NSA are added to a DEA database that includes intelligence intercepts, wiretaps, informants, and a massive database of telephone records. This is problematic because it appears to break down the barrier between foreign counterterrorism investigations and ordinary domestic criminal investigations. Because the SOD's work is classified, DEA cases that began as NSA leads can't be seen to have originated from an NSA source. So what does the DEA do? It makes up the story of how the agency really came to the case in a process known as parallel construction. Reuters explains. Some defense attorneys and former prosecutors said that using parallel construction may be legal to establish probable cause for an arrest. But they said employing the practice as a means of disguising how an investigation began may violate pretrial discovery rules by burying evidence that could prove useful to the criminal defendants. The report makes no explicit connection between the DEA and the earlier NSA bulk phone surveillance uncovered by Snowden. In other words, we don't know for sure if the DEA's Special Operations Division is getting tips from the same database that's been the subject of multiple congressional hearings. We just know that a special outfit within the DEA sometimes gets tips from the NSA. There's another reason the DEA would rather not admit the involvement of NSA data in their investigations. It might lead to a constitutional challenge to the very law that gave rise to the evidence. Earlier this year, a federal court said that if law enforcement agencies wanted to use NSA data in court, they had to say so beforehand and give the defendant a chance to contest the legality of the surveillance. Lawyers for Adel Dawad, who was arrested in a federal sting operation and charged, suspect that he was identified using NSA information, but were never told. Surveys show most people support the NSA's bulk surveillance program strongly when the words terrorism or courts are included. But when pollsters draw no connection to terrorism, the support tends to wane. What will happen when the question makes clear that the intelligence is not only being used possibly for terrorism, but it's also actively being used in domestic criminal investigations of other Americans? Some of the companies have begun to push back. Some of them have begun to push back on the backdoor mandates that are coming from government to get into our information. In one of the public confrontations, a top U.S. intelligence official by Silicon Valley, a senior Yahoo official, peppered NSA Director Mike Rogers at a conference on Monday over digital spying. The exchange came during a question and answer session at a day-long summit on cybersecurity. Mr. Rogers spent an hour at the conference answering a range of questions. The tense exchange began when Alex Stamos, Yahoo's chief information security officer, asked Mr. Rogers if Yahoo should acquiesce to requests from Saudi Arabia, China, Russia, France, in other countries to build a backdoor into some of their systems that would allow the countries to spy on certain users. It sounds like you agree with FBI Director Comey that we should be building defects into the encryption in our products so the U.S. government can decrypt, Mr. Stamos said. That would be your characterization, Mr. Rogers says, cutting the Yahoo executive off. Mr. Stamos was trying to argue that if Yahoo gave the NSA access to this information, other countries could try and compel the company to do the same. Mr. Rogers said he believed that it is achievable to create a legal framework that allows the NSA to access encrypted information without upending corporate security programs. He declined to be more specific. Well, do you believe we should build backdoors for other countries? Mr. Stamos continued. My position is, hey, look, this is from Rogers, Admiral Rogers. I think that we're lying, that this isn't technically feasible. He said the framework would have to be worked out ahead of time by policymakers, not the NSA. The back and forth came less than 2 weeks after Apple Incorporated chief executive Tim Cook leveled his own criticism at Washington, saying at a White House cybersecurity conference in California that people in positions of responsibility should do everything they can to protect privacy, not steal information. Mr. Rogers attempted to parry the questions, but also signaled he welcomed the debate. Still, Mr. Rogers did little to deflect recent accusations about NSA activities. For example, he refused to comment on recent reports that the NSA and its UK counterpart stole information from Gemalto NV, a large Dutch firm that is the world's largest manufacturer of cell phone SIM cards. I think the accusations continue to mount. Everywhere you look, you see the anger beginning in our tech industry. You see them wondering about having backdoor mandates built into their product. And I think the senator from Oregon has been great at pointing this out and has written several op-eds talking about what the harm is to this, of leaving basically a portal or an opening for our government, but that may well be exploited by hackers and may well be exploited by foreign governments. Does the senator from Utah have a question? Not from Oregon.
I think my colleague has made the point with respect to our government, particularly the FBI director, actually arguing that companies should build weaknesses into their system. And I wanted, because I note my colleague has been on his feet now for somewhere in the vicinity of 9 hours. And so I think we're heading into the home stretch. And I think for people who are listening, I think they really are, first and foremost, interested in how this Senate, on a bipartisan basis, is going to come up with policies that ensure that we both protect our privacy and our security. And as my colleague has said, that they coexist, that they are not mutually exclusive. So I think what I'd like to do is wrap up my questioning tonight by talking about how this bulk phone record collection and related practices is an actual intrusion on liberty. And to start the conversation, you have to first and foremost get through this whole concept of metadata. You know, we heard people say, well, what's the big deal about metadata? And for quite some time, we had senators saying, what's everybody upset about? This is just, quote, innocent metadata. Well, metadata, of course, is data about data, but it's not quite so innocent. If you know who someone calls, when that person calls, and how long they talk, that reveals a lot of private information. Personal relationships, medical concerns, religious or political affiliations are just several of the possibilities. Most people that I talk to don't exactly like the government vacuuming up private information if those persons have done nothing wrong. Now, this is especially true if the phone records include information about the location and movements of everyone with a cell phone. And we have not gotten into this in the course of this evening, but I want to take just a minute because I think, again, it highlights what the implications are. I have repeatedly pushed the intelligence agencies to publicly explain what they think the rules are for secretly turning American cell phones into tracking devices. They have now said that the NSA is not collecting that information today, but they also say the NSA may need to do so in the future. And General Alexander, in particular, failed in a public hearing to give straight answers about what plans the NSA has made in the past. Now, to be clear, I don't think the government should be electronically tracking Americans' movements without a warrant. What's particularly troubling to me is there's nothing in the Patriot Act, in addition, that limits this sweeping bulk collection authority to phone records. Government officials could use the Patriot Act to collect, collate, and retain medical records, financial records, library records, gun purchase records, you name it. Collecting that information in bulk, in my view, would have a very substantial impact on the privacy of ordinary Americans. And I want to be clear, I'm not saying this is what's happening today, but I want to make equally clear this is what the government could do in the future. So my question, as my colleague who has been on his feet for a long time moves to begin to wrap up his comments this evening, I'd like my colleague's thoughts on the impact of NSA collection of bulk records on innocent Americans. And I'd also be interested in his views with respect to why we have not been able to get the government to give straight answers about the tracking of the location and movements of Americans with a cell phone that took place in the past. And I'd be interested in my colleagues' thoughts on those 2 points.
Well, I want to thank the senator from Oregon for the great question and also for being supportive of and really being the lead figure from the intelligence community, from the Intelligence Committee, trying to make this better. I think so often our intelligence committees don't have enough people who are really concerned with the Bill of Rights as well as national defense. And so we get a one-sided view of things. And over the years, I think you've been able to continue this battle in a healthy way, understanding both sides of it, both our national security, but also understanding that who we are as a people is important, that we not give that up, that we not give up our most basic of freedoms in doing this. But I think that power tends to be something that people don't give up on easily. And so when you have power that you give to people, you have to have oversight. And so it's incredibly important that we do have oversight on what we are giving up. But it's also important that we see what's gone wrong. The FISA court model hasn't worked to oversee and to regulate the NSA. Because basically, when finally a real court looked at this, when finally the looked at this, what we find is that the appellate court was aghast that basically they were maintaining that this was relevant to an investigation. And apparently the way the process worked is the NSA says it's relevant, but there is no debate or dispute. It's just accepted as face value. But I thought the Privacy Commission put it pretty well, and they said, well, how can it be relevant to an investigation that has not yet occurred? We're collecting all the bulk data, and then we're gonna query it when we have an investigation. So you can't argue that it's relevant to an investigation because there is no such investigation yet occurring while we're collecting the data. And I think the Privacy Commission said that basically we're turning words on its head if we're saying that something like this is relevant. So I think the American people are ready for it to end. American people think the bulk collection of our records with a generalized warrant is a mistake and ought to end. And I think we are working very hard, and at this point, our hope is that between your actions and my actions, that hopefully leaders of your party and our party, my party, will agree to allow amendments to the Patriot Act. And the goal of being here today has been to say to, not only to the American people, but to say to the leadership on both sides and to all the members that we want an open amendment process, that the discussion of the Fourth Amendment is an important discussion, and that we shouldn't run roughshod over this by saying that there's a limit and a deadline and we don't have time for debate and we're going to put it off yet again. So I want to thank the Senator for Oregon for helping to make it happen, but my hope is that we can get an answer from the leadership of both parties that they're going to allow the amendments that your office and my office have been working on for 6 or 7 months now.
Well, my understanding of my colleagues' request, and that was my point of once again coming back to bulk collection of phone records and past practices with respect to tracking people on cell phones and any policies that may be examined for the future, is I think my colleague is saying that it's time to ask some tough questions. And many of these amendments we've been working on are basically designed to address these issues where we haven't been able to get answers in the past. And after 9/11, it was clear that the people of our country were worried, and there was just a sense that if you were told it was about security, you were supposed to say, okay, that's it. But that's not the kind of oversight that the Congress, particularly after you had a timestamp on the Patriot Act, we all thought it was going to end, then it was time to start asking, tough questions. And not enough tough questions have been asked, and my colleague in the amendments we're talking about really seeks to get answers and use that information to change practices on a lot of these areas that have really gotten short shrift in the past. And I appreciate my colleague talking about the FISA court in connection with this. This is, for our listeners, the Foreign Intelligence Surveillance Act court, certainly one of the most bizarre judicial bodies in our country's history, created to apply commonly understood legal concepts like probable cause to government requests for warrants to track terrorists and spies. But over the last decade, the FISA court has been tasked with interpreting broad new surveillance laws, and it's been setting sweeping precedents about the government's surveillance authorities, all of it being done in secret. And I will say, and I'd be interested in my colleagues' thoughts on this, that it is time that the court's significant legal interpretations be made public. Be made public so there's no more secret law. That the people of this country have the chance to engage in debate about laws that govern them. I also think that there ought to be somebody there who can say, on these questions, where there are major constitutional implications, there ought to be somebody there who can say, look, there may be other considerations than the government's point of view. So transparency here is critical so that Congress and the courts can hold the intelligence community accountable. And I want to mention once again, we are talking about policies. We are not talking about matters that are going to reveal secret operations or sources and methods. We are talking about policies. So I think it would be helpful, again, as we move to wrap up, if my colleague from Kentucky could outline some of the reforms in the foreign intelligence court area that he thinks would be most helpful in terms of promoting transparency and accountability that do not compromise sources and methods, because I think my colleague has had some good ideas in this area, and what, in my colleague's views, would be most important with respect to getting these reforms in this secret court in a way that would ensure more transparency for the public and still protect our valiant intelligence officials who are in the field.
I think that's a good question, and your office and our office have worked for a while to try to come up with some FISA reforms. One of them is sort of in the USA Freedom Act, but maybe could be better, saying that there ought to be a special advocate, or so there's an adversarial proceeding. One of the problems in the USA Freedom Act as it's written, though, is that the advocate is only appointed by the FISA court and doesn't have to be appointed by the FISA court. So it may well be that a FISA court that has given a rubber stamp to bulk collection may not be as inclined to give a special advocate. I also think it's important that, as you've mentioned many times, that we should be able to get outside of a secret court to a real court where you really have an advocate that's actually on your side. So I think allowing for an escape hatch for people to appeal. So for example, if you're being told by a FISA court that bulk collection of all of the phone data in our country is legal, you should have a route to an appellate court, an automatic route out of FISA to an appellate court. And I think the appellate courts are fully capable of redacting, going into closed session if they have to, but then you have a real trial with a real advocate on both sides. I think that's important as well. But I do have one question, or a question that you may be able to reframe into a question, and that is, can you give the public a general idea of what percentage of the overall problem of collecting American data is in the form of bulk data? And what percentage do you think is coming from executive order? And what do you think is coming from the 702 backdoor collection of data?
I would say that all of the matters we have talked about this evening, would be significant concerns with respect to ensuring that the liberties of the American people are protected without compromising our safety. So let's tick them off. Bulk phone record collection, millions and millions of phone records of law-abiding Americans. The executive order, 12333, that we talked about today, another very important area. And then Section 702, the Foreign Intelligence Surveillance Act area, where a foreigner is the target and the records of Americans are swept up in them. So I think we are addressing exactly one of the concerns that has come out in the last few days with respect to what Americans are concerned about. I know there's just been a brand new major survey that's been done. My colleague may have touched on it sometime in the course of the day, but Americans particularly want to know what information about them is being collected and who is doing the collecting. And in each of these three areas that I mentioned, there are substantial questions with respect to the privacy rights of Americans.
Well, one of the comments that we went through tonight was an opinion by one of the attorneys in the Bush administration, and they said basically that there were authorities that they were given that were inherent authorities under Article 2 that gave them the right to collect data on Americans, but they also then concluded by saying that Congress had no business at all reviewing this data, that there was no authority, that there were basically powers given by the president, to the president, that Congress has no ability. I guess I would be interested in the form of a question, if you can ask whether or not you believe there are Article II powers of surveillance of American citizens that Congress has no business questioning.
My colleague is, and I remember those days well, basically summing up the argument of the Bush administration. And I and others, pushed back very hard, because it would essentially, if taken to its kind of logical analysis, basically strip the legislative branch of its ability to do vigorous oversight. So my colleague has summed up what was the position of the Bush administration, but like so many other positions that were taken during that period of time, once there was an opportunity to make sure people understood how sweeping it was, what my colleague has described is an extraordinary sweep of executive branch power, basically relegating any role for congressional oversight to, yay much, and not on the central questions. So my colleague has summed up what the Bush administration said in those early days, and I had joined the Intelligence Committee shortly before 9/11, and I was struck because this really was the first example I'd seen of just how some in the executive branch would try to lay out a theory of executive branch power that really just takes your breath away.
I guess a follow-up to that would be, are those arguments still being floated from this administration that there are Article II powers? There is a debate going on over this Executive 12333, and the question is whether or not people are still trying to maintain that Congress has no ability to oversee or review it. But I've seen, at least in the lay press, that I think they say in the lay press there is some special investigation. Without going into details, is there some kind of investigation or evaluation of the executive order being done by us or one of the congressional bodies? That was in the lay press.
Yes.
Okay.
And what I can tell you is that I think there have been some changes, some improvements, but it continues to be a challenge. I mean, the reality, is you kind of look back from that period, and in those, early days, for example, John Poindexter made a proposal for something called Operation Total Information Awareness. Would have been the most sweeping invasion of privacy, in my view, in the country's history. And we decided, much like when my colleague talked about those early interpretations in the Bush administration, that this was an unacceptable expansion of executive branch power. But it wasn't until a young intern who was in our office late one night found some of the true excesses of this project. In effect, this young intern found that the program would actually encourage, as part of an experiment, encourage debate about assassinating foreign leaders. And people just found that, again, so out of the mainstream that when we brought it to light, Operation Total Information Awareness was gone within about 48 hours. So we have seen, my colleague highlighted the Bush administration proposal to basically have unchecked executive branch power, Operation Total Information Awareness. My colleague asked about 12333, which we have been reviewing. So yes, it is going to remain an ongoing concern, an ongoing challenge, because I think there is a sense that the executive branch is the only one that can really, deal with this kind of information in a timely kind of fashion. Well, what we've seen with respect to bulk phone record, collection is that that's been a program. It's not been about, timely access to relevant information. Experts with national security credentials, we talked about those individuals this afternoon, said this program does not make us safer, and we could get rid of it and obtain the information by conventional sources. So I think we have begun to rein in this unchecked executive branch power. And I think a big part of it has been the very valuable work my colleague has done in terms of trying to highlight these kinds of practices, and why I've appreciated the chance to work closely with my colleague since he came to the Senate.
I think one of the most exciting things probably is the court case, the Second Court of Appeals and their ruling. My hope, though, is that had been that it would go to the Supreme Court, but my understanding is that it's been remanded to a lower court, because I think one of the things that we really need is that we need a ruling that updates Maryland versus Smith. We need a ruling that talks about the fact that most people's records are being held in a virtual fashion. And I think there needs to be a ruling that comes from the court that acknowledges that you still retain a privacy interest in your records even when they're being held outside of your house. Because the idea of old-fashioned papers in your house, the concept is good that we should protect that privacy, but I think also the concept technologically is that you now will not have papers in your house, but you will have private matters that will be held virtually outside the house, and whether or not the Fourth Amendment protects those, because you often have advocates from the government who say Fourth Amendment doesn't apply to any records once they're outside your house or in other hands. And I really think that you don't give up your privacy interest when you let somebody else hold your records, that you still maintain an interest in privacy even though someone else holds these records.
I think my colleague has made an important point with respect to the Smith case. The Smith case was not made for the digital age. And that's a big part of what we have sought to do throughout this debate, is to try to make sure that people really understand the implications in the digital age of what these policies, mean for their privacy. And I see my colleagues are on the floor, and I want to give them some time. But since you mentioned this question of the court cases, I think there was really striking language recently by Judge Leon of the U.S. District Court for the District of Columbia, talking about really what the scooping up of all these records really means. Judge Leon said, and I quote here, "A few scattered tiles of information, when collected in mass, can reveal an entire mosaic about a person, including their religion, their sexual orientation, medical issues, and political affiliations." So you combine what the judge has described, I think correctly, as bulk collection, outdated court cases like the Smith case, which really wasn't updated in terms of what we would be facing in the digital age. And I think this really combines to create policies that have a chilling effect on liberty, and liberty for innocent, law-abiding Americans. So I want to say again to my colleague, who's now approaching 10 hours on his feet, that I very much appreciate him focusing on these issues. We've got a lot of work to do, because we know that there's been a pattern in the past where when we really get down to those final days, those last couple of days, there's always a lot of pressure to go along with some kind of short-term extension. And that's been the pattern year after year, every time there's been an expiration of the act. And I think what has been shown today is that kind of business as usual is just not going to be acceptable any longer. You have made that point. I want it understood that we are going to be pursuing the effort to make sure that this time we're not just going to re-up a bad law, re-up a flawed policy, and say that, you know, it's okay to continue a program. This was reauthorized, in effect, by the president a few months ago. This is going to be the last extension. This has got to be the last extension, and I'm committed to working closely with you and our colleagues to make sure that that's the case and to take the steps necessary to ensure that this is finally the last extension of a badly flawed law. And I thank my colleague for his good work.
Well, thank you. And I think that the American public's ready to end bulk collection. And I think there's a bipartisan, across-the-aisle, really approach that people want to end bulk collection and that the time is now and that we just can't keep extending this. I think probably the biggest deal is that Patriot Act doesn't even justify this. This is a program that needs to end because even those who read the Patriot Act, even those who loved the Patriot Act, acknowledge the Patriot Act does not even give permission for this. This is something we're doing that there is no permission for. It has to end. And I think the American people will be very, very disappointed in us as a body if it doesn't end. This is the time to do it. I agree with you. We're going to do everything we can to stop it. I see the senator from Utah. Does the senator from Utah have a question?
I do. I do. And at the outset of my question, I'd like to point out that while I disagree with you, Senator Paul, with regard to the specific question of whether or not we should allow Section 215 of the Patriot Act to expire in its entirety, I don't believe we need to do that. I would prefer that we pass the USA Freedom Act as passed by the House of Representatives by an overwhelming margin of 338 to 88 last week. While we disagree on that issue, I absolutely stand with you, Senator Paul, and I believe with the American people on the need for an open, transparent process and debate regarding this issue. And I also stand with you with regard to the belief that bulk metadata collection is wrong, is not something that we can support, not something that the American people feel comfortable with, and that it's incompatible with the spirit, if not the letter, of the Fourth Amendment to the Constitution of the United States, which we've all sworn an oath to uphold and protect and defend. Let's remember the text of the Fourth Amendment. The text of this amendment, penned in 1789, ratified in 1791, says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. These are not idle words. They're not surplusage. They're not there just for ornamental purposes. They're there to put important limitations on the power of government, to make sure that when government goes after things that are important to our personal lives, things that are part of our houses, things that are part of our papers, our personal effects, these things can't just be grasped randomly by government. Government has to have a reason for going after them, and government has to be constrained in some meaningful way, in the way that it goes after them. When the government relies on a warrant, the warrant needs to describe the things or the places to be searched with particularity. The people subject to them need to be identified with some particularity. And you know, these words were meant to be flexible. They were meant to be molded from time to time in different circumstances. They're not absolute in their terminology, and that's one of the reasons why they've endured for well over 2 centuries. and why they've been able to adapt to changes in technology. But there's not any reasonable construction of this language that I think can countenance what the NSA is doing and what we're talking about here, which is the bulk collection of telephone metadata. Now, what's happening is that the NSA is getting these orders from the Foreign Intelligence Surveillance Court, and these orders basically tell the telephone service providers, give us all your data, give us all your records, all of them. We don't really care whether they're relevant to an ongoing investigation of a particular person or of a particular terrorism ring or a particular foreign intelligence group of activities. We want all of them. Send all of them to us. We're going to put them all in a database. We're going to search them when we feel like it. Now, I don't dispute the claim made by the NSA that there are a limited number of people who have access to this database. Nor do I dispute, at least for purposes of this discussion, I'm not going to dispute, and I have no basis for refuting, the assertion that the people who work at the NSA are well-intentioned, that they have our national security interests at heart, that they're there to protect us. But even if we don't dispute any of those things, even if we accept all those things as a given, we have to acknowledge the very real risk that the same people who work there now might not be, in fact, we're certain that they won't be, the same people who work there a year from now, or 2 years from now, or 5 or 10 or 15 years from now. And we know something about human nature, which is that humans, when given power, will sometimes abuse that power. Sometimes they will abuse that power to the detriment of others. Sometimes they'll do it for personal financial gain. Sometimes they will do it for political gain. Sometimes they will do it in order to further certain agendas. That's exactly why it's so important to put boundaries around the authority of government. And that, of course, is what the Constitution is. This is our set of boundaries. This is our fence around government authority. It's there for a reason. It's there to make sure that the American people are protected against government. So first, the Founding Fathers put in place this structure that explained how government would work. It established the government. And then it carefully positioned this series of fences around the government to make sure that that power wasn't abused against the people. Now, it's interesting. When the Patriot Act was enacted, and when it was subsequently reauthorized several years later, Congress put in place a relevance requirement. Congress put in place in Section 215 of the Patriot Act a requirement that the business records that were obtained by the NSA pursuant to Section 215 of the Patriot Act had to be relevant to an investigation, relevant to something that they were doing. Now here again, as with the language of the Fourth Amendment of the Constitution, there's some play in the joints of the term relevance. Something might be relevant in one situation and not another. Whether or not it's relevant is going to depend on a lot of facts and circumstances pertinent to the investigation in question. But it stretches the term relevant, or the concept of relevance, beyond its breaking point, beyond any reasonable definition. If you deem something to be relevant, so long as it might in some future investigation, one that has not yet arisen, become relevant, such that you have to gather every record of every phone call made in America, such that the NSA wants to go after every record of every phone call made by every American going back 5 years, storing that series of records in a single database that can be queried for up to 5 years in advance. Let's just go through this exercise for a minute. Think to yourself, how many people have I called in the last 5 years? How many phone numbers, how many distinct phone numbers have I called in the last 5 years? Well, if somebody has called 1,000 phone numbers, or let's say made phone calls to 500 phone numbers and received phone calls from another group of 500 phone numbers, for a total of 1,000 phone numbers over the last 5 years, then that's 1,000 numbers. And then the NSA goes out one hop beyond that and connects each person, each phone number with whom the original person had contact. Let's assume that each of those phone numbers had in turn had contact with 1,000 phone numbers. You get to a million phone numbers pretty quickly. But each time the NSA collects these data points, each data point taken in isolation might not say much about that person. But as our friend and our colleague from Oregon noted a few minutes ago, it's by using that combination of data points, by aggregating all those data points together, someone can tell an awful lot about a person. In fact, there are researchers who, having used similar metadata and assembled similar sets of metadata in their own databases, have concluded that they can tell what religion a person belongs to, what political party someone belongs to, their degree of religiosity, and their degree of political activity. They can tell what someone's hobbies are. They can tell whether they have children, whether they're married. They can tell how healthy they are, what physical ailments they might suffer from. In many instances, they can tell what medications they're on. And all of these things are made more efficient by virtue of the automation in this system. And so while it's true, people point out that under Section 215 of the Patriot Act, under this particular program, the NSA is not listening to telephone conversations. They're not listening to them. Interestingly enough, this is very often a straw man argument that's thrown out by those who want to make sure that Section 215 of the Patriot Act is reauthorized without any reforms. They claim that those who are opposed to this type of action are out there falsely claiming that the NSA is listening to phone calls under this program. Well, that accusation of falsehood is itself false. That accusation of falsehood is itself a straw man effort. It's a red herring. It's a lie. It's a lie intended to malign and mischaracterize those of us who have genuine, legitimate concerns with this very program. Because the fact is, we don't make that argument. The argument we're making is that the NSA doesn't even need to do that. The NSA can tell all kinds of things about people just by looking at their data. And because it's automated, and because it's within a system that operates with a series of computers, they can tell it very quickly. It's a lot less human resource intensive than it would be if they were having to listen to countless hours of phone conversations. It's a lot more efficient. Now again, I want to be clear. I have no proof that the NSA is currently abusing this particular program. I'm not aware of any evidence that such abuse is occurring. And I'm willing to assume for purposes of this discussion that that's not occurring. That the men and women who work at the NSA and have access to this database have nothing but the best interests of the American people and American national security at heart. But how long will this remain the case? And how safe, how fair is it of us to assume that this will always be the case? We can scarce afford, for the sake of our children and our grandchildren and those who will come after them, we cannot afford to simply assume that this will always be the case. We have to remember what happened a few decades ago when Senator Frank Church and his committee looked into wiretap abuses that had happened within the government. We have to remember the Church report that was released at the end of that investigation. That report concluded that every presidential administration, from FDR through Richard Nixon, had utilized law enforcement and intelligence gathering agencies within the federal government to engage in political espionage. So that technology, which was then only a few decades old, had been abused. It had been abused for a long time. The abuse of this technology had gone, of course, unreported for many decades, but it had nonetheless been occurring. Again, I don't know, I can't prove. I have no evidence that such abuse is going on right now. But I think all of us in order to be honest with ourselves, would have to acknowledge that there is at least some risk that if it's not occurring now, at some point it will occur in the future. This temptation is simply too strong for most mortals to resist, particularly in an area such as this, where there is, with good reason, very little ability for the outside world to observe what's going on inside that particular government agency. Now, that's exactly why I happen to support what was passed by the House of Representatives last week. What was passed by the House of Representatives last week in the form of the USA Freedom Act was something that would require the NSA, instead of going out to all the telephone companies and saying, send us all your records, we want your calling records, just give us your records. We don't care whether it's relevant to a particular phone call, particular to a specific number that was itself involved in terrorist activity or foreign intelligence surveillance activity. We don't care about that, just send it to us. Far from doing that, what the USA Freedom Act would require is for the government to show that they needed records related to a telephone number that was itself involved in some kind of activity. They wouldn't have the ability to go to all the phone companies and just say, send us everything. They would instead have the power to get a court order to get those records of those phone calls that might well be connected to terrorism based on their contact with a phone number that was related to such activities, or their contact with somebody else with some other phone number that was in turn having some kind of communication with someone involved in those activities. Not all of us agree on this. And Senator Paul, you and I don't agree on this particular bill, but we do agree on the underlying issue. And we also agree that the Senate works best, that the Senate serves the American people well when it lives up to its self-described reputation as being the world's greatest deliberative legislative body. That we would all be better off if we were able to put this bill on the floor right now. If this bill were able to come to the floor and it were subjected to open, honest debate and discussion, that the American people could see that we were debating this, and that you, Senator Paul, and some of our other colleagues who have ideas as to how we could make this legislation better would have the opportunity to introduce, in the form of an amendment, improvements to this legislation. I heard you outline quite articulately just a few hours ago some very thoughtful reforms, some very well thought through amendments, improvements that you would make to this legislation. I think we would all be better off if we took that kind of approach. Now, we've seen in the last few months what can happen. When we came back here in January, we saw that the desks in the Senate chamber had been rearranged. Many of us were pleased by that. We didn't shed a tear at the realignment of the desks. And we've noticed that this realignment of the desks reflected a change in the political attitude among Americans. But more importantly for us, it was the precursor to some very positive developments in the Senate. We saw that within just a few weeks after this shift in power occurred, we had cast more votes on the floor of the United States Senate than we had in the entire previous year. Within a few months, we had cast more votes on the floor of the United States Senate than we had cast in the 2 years previous to that. This was a good sign. It's not just because we're here to cast votes. It's because those votes represent something. They represent the fact that we're actually debating and discussing, and we're allowing each senator to have his or her views heard out. We're putting ourselves on record as to what we believe represents good policy and what does not. I think we'd be in a much better position to address the national security needs of our great country if we had such an opportunity with respect to this legislation, which is one of the reasons why I came to the floor yesterday, along with one of our colleagues, the senior senator from Vermont, and asked unanimous consent to bring this bill, the House-passed USA Freedom Act, H.R. 2048.